It's very nice to be here. This is the second health tech conference I've attended, and looks very, very good. I'd like to introduce my colleagues on the panel. Kirk, if you could just introduce yourself.
Sure.
Mike.
Okay. There we go. My name is Kirk Nara. I'm a partner with Wiley Ryan in Washington, D.C., which means I'm a lawyer from Washington here to help you. I have been involved in the topics we're going to talk about for close to 20 years at this point, going back to the early 90s when HIPAA for me meant healthcare fraud statutes, which deals a lot with the healthcare industry. That was also, of course, the time when we solved the healthcare crisis through the HIPAA statute, and started us down that path of administrative simplification, which is what you're hearing about with transactions, which one point that wasn't quite made in the last panel was that that's been way more expensive and took far longer than we thought with far less benefits. So it's sort of a lose-lose, I guess, all around so far. But so I've been involved in these issues for a variety of years. I have a good range of clients across industries, health plans, healthcare providers, a lot of service providers. I've also worked a lot on the policy side through involvement with a couple of government agencies. So hope to be able to give you a sort of a broad sense of what's going on in the privacy and security area and how it's going to affect really the drive towards innovation and technological change in the healthcare space.
Great. And Linda.
Good afternoon. I'm Linda Kuntz. I'm a senior advisor for privacy and strategy at the MITRE Corporation. And for those of you who might not be familiar with MITRE, we're a not-for-profit corporation that works in the public interest, and we operate 6 federally funded research and development centers. Those are called FFRDC, kind of for short. And we work in partnership with federal agencies, and our only clients are federal agencies, on solving problems that are really, really difficult. And it's a long-term relationship that we work with folks in. What I've been doing for about the last 3 years is supporting the Office of the Chief Privacy Officer in ONC, and also their Federal Advisory Group, which is, you may be familiar with the Privacy and Security Tiger Team, which makes recommendations to ONC about privacy and security policy issues. So I've been pretty much immersed in that policy-making world for several years. I find it really, really interesting to be here and find out about, how people are finding, actually implementing some of the policies that Washington has come up with. And I think I'm the only non-lawyer up here, so maybe come at it from a little bit different perspective.
Right. So thank you. So I think we're going to talk first, I guess, a little bit about the HIPAA Omnibus rule that was recently passed, the rule. I think most people here are familiar with the rules, and what has happened is the Omnibus rule recently happened. It became effective March 26th, and there's a 180-day period during which people have to come into compliance with it. And just very briefly, what the final modification to the rule was, the final rules were the final modifications to the HIPAA privacy, security, and enforcement rules. And briefly, they make business associates of the covered entities directly liable for compliance with certain of the HIPAA privacy and data security requirements. They strengthened limitations on the use and disclosure of protected health information for marketing and fundraising purposes. They expand individual rights to receive electronic copies of their health information and to restrict disclosures to health plans concerning the treatment. There's other changes. There's also the final rule. There's 4 rules. There's a final rule adopting changes to the HIPAA enforcement rule to incorporate the increased and tiered civil money penalty structure provided by the HITECH Act. And there's also the final rule on breach notification for unsecured protected information under the HITECH Act, and also the final rule modifying the HIPAA privacy rule as required by the Genetic Information Non-Discrimination Act to prohibit the most health plans from using or disclosing genetic information for underwriting purposes. Those are the 4 rules that are the final rules in the HIPAA Omnibus rule. and they will occasion changes in business operations and practices of actors in the space, both healthcare providers, but everyone acting in the space. Like, Kurt, do you want to speak a little bit of what you have seen or what you expect to be seeing coming down the line?
Sure. Let me give folks, just make sure to set the stage a little bit. I mean, what we're talking about are final regulations coming out of the high-tech law, which was obviously passed in 2009. You know, you're familiar with the incentives for electronic health records. What Congress decided in its infinite wisdom was, since they really wanted to encourage healthcare providers to utilize electronic health records, they would make sure to create new privacy and security regulations that were going to create compliance obligations for them. So right from the start, you have a little bit of a disconnect on what they're trying to do. And then when you start to read the law, most of the provisions of the law have nothing to do with electronic health records. So it was a very dysfunctional statute from the start. But if you read the statute, you could see, okay, they want to change the rules in this way, and this way, and this way. And then a year and a half later, the Department of Health and Human Services came out with a regulation that basically, a proposed regulation that basically said nothing in the statute means anything until we tell you what it means, so you don't have to do anything yet. So what we're now, in fact, doing with this omnibus regulation that Walter was mentioning is essentially 4 years later coming out with a rule that largely is a clerical transfer from the statute into the regulations. But we've been, you know, most of the things that are in this final rule are things that we have largely known about for 4 years. HHS just hadn't started the clock ticking yet. So let me try to give you a sense of what I think are the most important provisions here. And there's a limited number of them, but they have a very broad impact on the healthcare space. What has clearly been the most important part of these regulations so far are the provisions dealing with security breach notification. And what this does, and again, this is from the statute, and this is a part that's been partially in place for a while, is it forces healthcare companies in certain situations to give notice to patients about security breaches. And that has had an enormous effect on every component of the healthcare industry, because everyone in the healthcare industry has had security breaches. Those entities that don't think they've had them just don't know that they've had them. So that's been a big deal, and it flows up and down in the system. So it affects a lot of the breaches we read about in the newspaper involve vendors and service providers and downstream contract providers. The breaches are a little bit strange because these breaches stem from some laws in other areas that applied to identity theft situations. So if somebody steals your credit card and your social security number, there are state laws that say you have to give notice about that because you can tell the person, you know, be careful about your financial records, check your credit card statements, check your credit reporting and things like that. We now have a law for the healthcare industry that says if you lose any kind of sensitive information, let's say your HIV information, you have to write a letter and notify people and tell them what they should do about it. I don't have any idea what I should tell them to do about it if somebody loses an HIV record or any kind of record. Dear patient, we're sorry we lost your records, therefore you should, you know, they haven't really filled in the blank on that. I know what to tell them if we lost their bank account information. I don't know what to tell them if someone stole, or more likely we lost that. So that's having a big impact on the healthcare industry. It has already had a big impact. What this final regulation did was it changed the standard a little bit about when you have to tell people, and we're going to still work through that. But that's sort of the biggest impact so far. The other major piece that I want people to be aware of, and this is part of a theme that I think we're going to talk about today, which is sort of who these rules apply to, which is when the rules first were created, HHS was limited to who they could apply these rules to. They're called covered entities. That means healthcare providers, doctors, hospitals, and health plans, which is mainly health insurers. It's also, oddly enough, the benefit plans of most employers. But that was it. It wasn't anybody else. And so HHS invented this idea of a business associate, which is essentially a service provider to a hospital or a health insurer, and said you have to have a contract. The hospital has to have a contract with their service provider that passes through contract obligations to those people. But that was all they were. They were contract obligations, and if you didn't do it, you had a breach of contract, but the government couldn't go after you. The high-tech law changed that. We've known that for 4 years. These final rules finally implement that. So what this does is it expands much of the HIPAA regime to all these service providers, and to anyone who's downstream from those service providers. So what this has done is dramatically increased the scope of who these rules apply to. So it's not just these healthcare entities, but it's anyone who contracts with those healthcare entities and anyone who contracts with anyone who contracts with those healthcare entities. So many, many companies have to follow these rules now, and if you add it into all the companies that have employee benefit healthcare programs, most companies have to have something to do with these HIPAA rules, but it's not everybody, but it's a whole lot of people. The major impact for these service providers is going to be on the security front because they now have to follow the entire HIPAA security rule, which is a major challenge. On the privacy front, people are very nervous about this, but if they're nervous, they actually don't understand the obligations, because what the obligations are is basically the obligation subject to enforcement to follow what's been in your contract since 2003. And I have all these business associates that call me and say, oh my God, how are we going to do this? And I said, well, what have you been doing for the last 10 years when you were already supposed to be doing this? So big expansion, material impact on the security front, exposure and liability on the privacy front, but really shouldn't have to change behavior all that much. And we can drill down into a lot of the other details as we go forward.
All right. Do you have any comment, maybe, or would you like to?
Well, I mean, that was a great summary
Yeah.
of some of the most sort of impactful changes that have been brought about. There's others that I think we'll probably get into, but I will add on the breach notification. I mean, it's been sort of interesting to watch breach notification over the years because it was sort of late to the party after there was a lot of information, personal information that was collected, and then finally people realized that, oh my gosh, we can breach millions of records in just like a single bad move, and so we better find out some way to deal with this. And I mean, this is clearly playing catch up in this area as well. I think one of the things I would mention about the breach notification is that the new regulation basically presumes that if you've had some kind of inappropriate disclosure, it presumes that's a breach, and that you're probably going to notify people that their information has been breached. The only way you can maybe mitigate that is that if you do some kind of sort of standard risk assessment, and you can conclude that there's a low probability that the information has really been compromised. So it seemed to me that they were making it very clear that covered entities and business associates of all types are going to have the burden to show that they're going to have to notify unless they can show otherwise, and the burden is on them. Well,
Is that an easier standard, do you think, to meet than a risk? It was risk of harm, and now it's just a risk assessment using a number of points.
Yes.
Is that easier to do or hard? I mean, who does it benefit? I mean, who gets the benefit of that, I guess?
To me, in some respects, it might be easier because it makes it clear that you're probably going to have to notify if you've had some kind of breach. And some entities will say, I'm just going to go ahead and notify, I suppose, instead of doing the risk assessment. I mean, that's a way that they could go with that scenario. I'm not sure though, from a cost standpoint, that necessarily is the right way to go, though.
Let me jump in on that. I mean, I guess I have a slightly different take on that. I mean, most of these rules, as I said, we've now been working through them for 10 or 12 years. There's a real history to these, and my take is a little different. I mean, Congress passed this law about breach notification, and what it says is you give notice if there is a compromise of personal information. And HHS, the first time they looked at it, said, well, what that means is we're going to require notice if there is a significant risk of harm, financial, reputational, or other harm. And so people have developed ideas to work with that system. They got a lot of flack for that. They got a lot of criticism, including from Congress, for the creation. It depends on my audience. I say creation in some audiences. Usually I say clarification because I like the standard. They clarified that it meant significant risk of harm, but they took some criticism for that. So what they did in the final rule, in my view, was basically a brilliant political move. They took out the words significant risk, but instead they said, you don't have, there is a presumption, and that's an important change, although I think people were acting that way anyways. But what you do is you give notice unless you can demonstrate that there is through a risk of harm, no compromise of the information. And HHS has even said explicitly in presentations, it's not in the rule, that that's basically the same thing as the significant risk standard. They're putting a little more meat into it. So I think we're still going to have situations where, sort of routine mistakes. You send in explanation of benefits to the wrong provider. You have the wrong employer group receive, things that happen, unfortunately, too regularly. I mean, I don't want companies to look at this and say just because they don't have to give notice means your security is very good. I mean, the number of security problems is enormous, but I do think that HHS continues to recognize that it would help nobody to just send these notices out all the time, because there's nothing for people to do. There's actually nothing for them to be worried about. It would scare most patients to get notices that they really don't understand. So there is still some meat on that standard, but I think it's going to take people a while to work through that. One of the things I've said to people, and I encourage you to take this back to your organizations, is you've got 6 months to implement this new standard. Anytime you have a situation right now, I would look at it under both standards and figure out whether the answer is different. They won't be different in most circumstances. If you find out there's a lot of difference, my guess is you're doing one of the standards wrong. But use the next 6 months to sort of try these standards out and figure out how you're going to do your risk assessment as you work through these details. But again, there are lots of breaches, and the major result of these security breach notice statutes is to encourage people to have better security, because even though that risk of the massive million record breach is clearly out there, the breaches that we see all the time are small, stupid human errors. I mean, that's most of what we're seeing. The cases that I've been involved in that have caused the most problems have been lost thumb drives, CDs that should have been encrypted that get lost, packages that go to the wrong, all stuff that is manageable and sort of low tech. The number of, true hackers stealing all the records, there are some of those, but that's really not the bulk of the problems.
All right. So I think also, I guess the new rule raises the bar for business associates, and you touched on that a little bit earlier, Kurt. But from a practical perspective, what would you think are the three, if there are 3 things that you could identify that people should be concerned about, they could do right away? Or?
Well, for business associates, again, these are service providers. So these are anybody that provides services to healthcare companies. It is important to understand that flows downstream. So I mean, the idea makes sense. I mean, from HHS's perspective, they're trying to protect patient interests, and they don't want patients to lose protections for their information simply because a hospital chooses to outsource a function or that outsourcing company outsources something else. So the logic makes sense. I mean, I think everybody sort of understands that. But I think the other piece to keep in mind is that every step away from the hospital, the protections are often going to be less because those people have no relationship with the patients. They may or may not be in the healthcare business. They may not even know that they have healthcare information. I mean, if you're you're an accounting firm who has clients in every possible industry, and one of your clients happens to be someone who works for a hospital, and you happen to review the account receivable in the course of doing their books, all of a sudden you have patient information and you have to follow these rules. So you have to think about the downstream issue. The biggest compliance challenge for these service providers is clearly the security rule. Because what people have to do today under the security rule is have reasonable and appropriate safeguards. That's all. It's one sentence. And any good lawyer can convince somebody that you have reasonable and appropriate safeguards. That's not a hard standard. Under the new rules, you have to follow the whole HIPAA security rule, all, 57 parts of it. It's very challenging. It's very process-oriented. It's very documentation-heavy. It's going to be particularly difficult for companies who aren't just healthcare service providers. I mean, if you're a company whose sole clientele is the healthcare industry, you'll be able to adjust to this program. But again, if you're an accounting firm, you're a law firm, you're a consulting firm, you're all kinds of firms that have clients in all kinds of industries, you have a security program. It's just probably not a HIPAA security program. So figuring out what you're going to do to change that is really the biggest challenge. And from my perspective, you asked for top 3, Walter. That's 1, 2, and 3 on the list, is that security rule. The privacy rule, as I said, shouldn't require material changes as long as you've been doing things right historically. Lots of people have not been doing them right historically. So people need to reevaluate their positions on everything on the privacy rule, but again, the substance hasn't changed. The only real change is what happens if you do something wrong, because now the government can go after you as well.
All right, thank you. Linda, would you want to add something maybe? Or?
I think there wasn't much I could disagree with there
Yeah,
because, I mean, frankly, I mean, I think that is one of the implementation challenges is that the further you get away from the covered entity, and I agree, HHS did this because they didn't want people's, shall we say, protections to lapse just because the information changed hands one more time. So from a conceptual standpoint, it made a whole lot of sense. But as you get further away from that covered entity and the knowledge is less of what, you know, HIPAA is supposed to do, it's going to be an implementation challenge. And I also think that fairly too, is that perhaps some of the implementation to date hasn't been that good yet. And so, you know, this is sort of a chance to go back and reevaluate where we are and try to strengthen what we do have and make sure that we're in compliance with the rules that we already had.
And let me just add another piece to keep in mind from the, you know, I know a lot of you work with the covered entities themselves, work with the healthcare providers. I mean, one of the implications of this whole package of changes is on the security breach side again. I mean, all of those downstream business associates and downstream service providers have their own obligations. That's very clear. However, when there's a security breach, it's your problem. It's ultimately your contact with the patients. The service providers have obligations to tell you about the breaches, but if you hire a service provider who's got bad security or has a problem, it's ultimately going to be your problem because of these breach notification obligations. Again, the obligation to tell the patient or the insured is on the covered entity, the hospital, the health insurer directly. Everyone else just has to report upstream. So I do think this is going to have an impact on due diligence and who you pick as your service providers. I mean, that's always been an important issue, but I think it's increasingly important now, particularly because some of the biggest breaches that we've seen in the industry over the past couple of years have involved downstream service providers. And, you know, the name in the newspaper is the hospital, not the downstream service provider, because they're the one that has to send the letters out.
Right, and there was something that I think probably many people saw about the breaches are quite often a really high proportion are caused by business associate issues, not covered entity issues. I did want to speak a little bit about cloud, and I guess there's been a movement, I guess, in this industry as in others to cloud computing. And do you think that poses particular issues or not? This is like any other outsourced service provider.
I think it is a very specific challenge for the healthcare industry. It's a risk for any industry. You've got challenges because you don't know much about the cloud providers, frankly. You have a lot of questions about what law even applies. You've got international questions. I'm not going to go into that, but that's sort of a baseline for every industry. In the healthcare industry, you've got a couple of different challenges. First of all, a lot of the cloud providers, I'm not going to say everybody, but a lot of them, sort of the bigger they are, the more likely they are to fit into this category, basically say, here's what we got, take it or leave it, sign the papers. And they aren't your papers. They aren't business associate agreements. They're often not even willing to accept the fact that they're business associates, et cetera. So that means two things. It means, one, your contract with the cloud provider is probably not going to say the right things. That's a little risk. I don't want to overplay that. But what they're not going to have is give you any particular confidence that they're following these security rules. A lot of them don't seem to realize that they're subject to these new rules, whether they sign a contract with you or not. But I think the challenge for healthcare companies is whether they can get sufficient confidence in what the cloud providers are actually doing with their information and how it's been protected. I actually published a piece earlier this year, I guess, or late last year, that essentially was a message to the cloud industry, which was, you guys are going to have to change your ways, particularly your openness to your customers if you want to get healthcare clients. There obviously are healthcare clients who are willing to go there anyways, but I think the healthcare industry is likely to lag behind a little bit in a smart, cautious way moving towards the cloud. The other issue that's been interesting is the sort of international component of that, and where is the data? And if you have cloud providers who are really offshore companies, they may not even be subject to jurisdiction here in the United States. You know, the ability of HHS to go after a business associate who's based in India, for example, they have a theoretical ability to do that, but it's actually very hard to do that. So there are some gaps there, and again, I think it places just more of a priority on really knowing who your vendors are, knowing what they're doing, and that also means knowing what your vendors are doing with the data. You may have a no cloud policy yourself, but if you hire a vendor who themselves uses a cloud vendor, you've sort of backed into the cloud.
Right. You pointed out again that downstream responsibilities and where they go, and how many cloud providers themselves outsource parts of what they do to other folks. And again, the first customer, the covered entity, may not know, or the original customer may not know how far along the processing goes, on and on down to further subsequent subcontractors. And the more remote you get from the covered entity, the more difficult it is and the more risky it is, of course.
Do you want to see if there are questions out there at all?
I'm sorry, does anybody have any questions so far on any of these issues?
There's one back there.
Yes.
Or just shout.
That'll work.
Well, it's not so much a question, but I thought it was important to add on your comments. It's not so much a question, but I thought it important to add on your comments on business associates that, you know, there were two components in my reading of the rule that really are relevant, and one is the fact that you're a business associate whether you have a BA contract or not. If it looks and smells like a business associate, you are going to be considered a business associate under law, even though you're not putting a shingle out or getting an agreement. And the second thing, it's not just the providers or the covered entities putting notice to the individuals. It's also the risk of the media notice and the other put on the website. Particularly, I mean, if you have 1,000 records gone and the rule is 10 addresses are bad, you have to put it on your homepage. If you have 500, breach of 500, you have to notify local media. You have to keep the logs and report to HHS annually. So it's a lot more than just notifying individuals. There's a tremendous of other obligations and risk involved.
No, that's right. I mean, they're two separate points, so let me just sort of highlight them. The first point is an important one, which is, you know, in the past when business associates had just contract obligations, if you didn't sign a contract, you didn't have the contract obligations, obviously. And what this change does is it basically says HHS gets to decide if you're a business associate or not. So some of the companies who have in the past a cloud company might be a perfect example. If a cloud company convinces its hospital client that it's not a business associate, that's fine. I mean, I encourage the hospital not to accept that, but if they do accept it and they don't ask about it or whatever, that doesn't mean from the cloud provider perspective that they're off the hook. However, if you have things like security breaches, you may not learn about it because, but that just means there's an enforcement issue later. So that's clearly going to be a relevant issue for people who are sort of at the margins of being business associates. We're seeing that with cloud providers. We're seeing it with communications companies, telecom companies, things like that, who pass along information but may or may not be using it. The second point about notification is absolutely correct. There's a whole series, a whole litany of obligations that go along with the breaches. A lot of those other obligations you mentioned, the website and the media and things like that, are nothing more than a public spanking. I mean, there's no benefit to patients from that. It's just a hall of shame. And so, I hate those parts of the rules. And I one of the things that I often counsel people is, I want you to err on the side of giving notice to people. If it's a close call, even remotely a close call, I think you should notify the people. But I think you can actually be a little more aggressive in your reading of your obligations when you go to things like the media notice. I mean, the media notice is also kind of silly because it's not really a media notice. It's you have to put out a press release. That doesn't mean the papers ever run anything with it. So most of the time, the papers don't care about these things. So you send out a press release that nobody reads, that never, But it's better not to have to send out that press release because there's no upside to you in sending out the press release.
All right.
Any other questions at this point? There's another one up here.
Hi, Kirk. You talked a little bit about healthcare organizations need to do a better job evaluating their vendors and who they work with. Is there a set of criteria that you would advise a healthcare organization to take a look at when evaluating vendors?
That's a good question. I mean, here's the thing. I mean, an average hospital, for example, might have 1,000 vendors. There are some that have a lot more than that. I mean, a small hospital might have less than that. So there's a limit realistically to what you can do. And there's sort of three phases to thinking about those issues. One is the front-end due diligence. You haven't hired a vendor before. You're looking at them. You're either doing an RFP or whatever you're doing. So you want to figure out how much you're going to ask them at that point. I do encourage you to ask about their security program. I do encourage you to get some kinds of representations about their program. I do encourage, you also need to think about what they're doing for you. I mean, not all vendors are created equal. So think about that front end. Then you have the contracting end where there are mandatory provisions in the contracts, but there are lots of additional details. I guess one thing I don't particularly encourage people to do, and I'm unfortunately seeing this a lot in contracts, is companies write into their contracts, here's our security program, you have to agree to follow that. That doesn't make any sense to me because my security program and your security program don't have to be the same for yours to be just as good as mine. Yours might be better, just not the same. So think about that contracting phase. Then you also have a sort of post-contract monitoring piece. What I encourage people to do is be smart about their vendors. I mean, every company can look at their system and say, you know what, here are the 5 people that have the most impact for us. That means their volume, their sensitivity, their interactivity with, their direct contact with members, whatever it is. Pick 5, pick 10. I'm not saying pick 1,000, but I do think you want to have a regular program to keep up with people. You want to be careful about what you're sending them. You want to be thoughtful about what kind of vendors you're, again, the company that stores your leftover boxes of patient records that haven't been converted to electronic yet, I have a limited number of issues with them. I don't really need to understand their computer system. I want to know what the physical controls are there. If you've got if somebody's hosting your electronic health records and dealing with access to patients directly, that's a critical vendor. I want to have a lot more information about them before I go forward with them.
Right, and it really, if I can just add just a small thought, it really does take knowing what you're doing. Usually I have been involved in a number of negotiations like this, and it really takes sitting down, both parties, and figuring out what the operations are that you're going to be outsourcing or you're going to be contracting for. The business people, operations people, technology people, compliance people, they all have to be part of the game so that there's no surprise later on, oh, I didn't know that happened. And so that's a really important part of the process is people have to know what they're doing. If you are contracting with somebody to do certain services, you really need to know what they're doing and what the implications are. And that really means getting all of the necessary parties involved if you're contracting for those things. Other questions? So now I think one of the things is I wanted to speak about patient rights and maybe some of the new patient rights that are involved in the Omnibus rule. If you can touch on that, or
sure. There's a couple of different rights that have been created by the HIPAA rules. There's the right to access your medical records. You get a copy of your medical records. You have the right to amendment, which is basically if something's wrong or you think something's wrong, there's a process to get it changed. There's a right to something called an accounting, which is essentially a list of certain kinds of disclosures. What these rules did was they made some changes to them. I don't want to overstate them because I think they're going to be of limited impact, but they've changed. You now get right to an electronic copy of your records in certain circumstances. That, again, some people will want that. Some people weren't willing to give it before. Now you have to give it. There's an interesting provision that's a right to what's called a restriction on communications, which is basically if you're a patient and you want to go to a doctor and pay for a service yourself, you have the right to say to the doctor, do not tell my insurance company about this. I think it's a bizarre provision. It basically seems to be designed to let people lie to their insurance companies. I know lots of people don't like insurance companies. I just think that's a weird thing to build into the law. If you're a hospital or a medical provider, all the obligations are on you. It's a real challenge, and we're talking about integrating records and interoperability. Now you have a situation where certain pieces of the information can't really be in that record because the health insurer might see it. And so lots of compliance challenges for not any particular material patient interest that I can really see on that. The one individual right that could have an enormous impact has not yet been implemented. It's, they talk about an omnibus regulation, and it said it's been 4 years in the making, but it didn't actually cover everything in the high-tech law. There's a requirement in the high-tech law to change this accounting right. Let me just have a quick show of hands. How many of you even know what the accounting right is in the HIPAA? All right, one, good. That's one more than most audiences I get. The HIPAA accounting rule is the single biggest waste of time in everything in HIPAA. And so what Congress did was they said, oh, let's make it harder to comply with because nobody cares about it. So they basically said patients are entitled to an expanded list of disclosures, and then when the proposed rule came up, not only did HHS implement that, but they then blew it up and said, you have a right. And let me make sure people understand what this right is. What they said in a proposed rule was you as a patient have a right to ask your hospital, for example, for a list of every person by name who touched any piece of your information. So every nurse, every doctor, every billing clerk, every claims person, and you can ask, that means for all the business associates, it means everybody downstream. Think about the record keeping that would be required of that. I mean, one of the integrated health systems did a sample for a patient. They brought in a stack of paper that was this high of just a printout of everybody who touched the records for that. So HHS got appropriately criticized for that, and they basically haven't implemented that. I think they're going to throw that away and start over. But be aware of some of these things. I mean, the HHS is really feeling its way on what they want to do for patients. The rationale for this, again, ill-fated proposal was basically patient empowerment. They wanted to give patients an understanding of what was happening with their information. I just think they screwed it up in terms of what they were trying to accomplish. But I don't think they've given up on trying to get patients more involved in their health care, which on the one hand is usually a good thing, but it's been very hard to tie into these patient rights. And again, these are rights that even though everybody in this room has these rights, my guess is none of you have ever used any of them as a patient. Very few patients actually seem interested in them. So there's a lot of confusion about these rights. The actual changes so far have been modest. They may actually have a big cost, even though there's not much impact, not much use of them. But unfortunately, we haven't seen the end of that yet either. Question in the back?
Question?
We're going to need to digitize a paper record and provide it to them?
You clearly do not need to convert to electronic. It's essentially, it's a limited right in a form agreeable to the parties for records that are already electronic. I mean, this was actually one of the, I mentioned at the beginning that, the high-tech, the privacy and security changes were an offshoot of the incentives being given to providers to implement electronic health records. But then most of the changes had nothing to do with electronic health records. The accounting and access provisions were tied to electronic health records. HHS has blown it up a little bit and expanded it, but it's all, so there's clearly not an obligation to convert paper records to electronic. And it's not even an obligation to give all electronic records in all circumstances. It's a limited set of records in any event. All of you will have, all of your privacy and compliance people should know the records that patients have a right to if they're already essentially in a readily available electronic form. You have to make them available in electronic form. The idea was essentially, to let patients do things like populate their own personal health records. So you could get that, and they could tell you, don't send it to me, send it to Microsoft Health Vault or wherever, WebMD, whatever it's going to be. So there's some challenges there, but it's not a massive conversion effort.
I mean, if you have records like an Excel spreadsheets or MS Word documents, then presumably, it's easy for you to get access to them and provide them to the person who asked for them. That's what that would entail, right?
Right. One of the reasons that I ask is because if you have these patients with large volumes of charts, we're charging them $100, $200 to copy them and provide them on paper. And my understanding when I read the Omnibus rule was there was a cost provision about how much you could charge them to give them
Oh, couldn't co-
electronic. So
Yeah.
what I guess what I'm worried about would be, is there an interpretation that I have to, it would be cheaper for the patient for me to scan them and put them as a PDF on a thumb drive than charge them $200 for copying?
The cost of.
Well, again, there's a couple of steps in this. There is no requirement in the rule to convert the paper to electronic. Absolutely clear about that. There may be lots of reasons why you want to do that, and there may be lots of reasons why you want to, my guess is, again, most providers are not getting very many requests for these. They're getting requests from other providers to send records and things like that, and you do that all the time, and there's lots of reasons to do that electronically. Everybody's going to have their own approach to what they do, and frankly, it doesn't even have to be one size fits all within your patient population. I mean, you could easily say to a patient who's been in a hospital for a single came in for back surgery and hasn't seen you for any other reason, that record's all electronic. You'll make that available electronic, but somebody who's been there a bunch of times and also works in one of your physician clinics, you give them something else. So everybody, I mean, there clearly is a compliance obligation associated with this. One of the challenges is going to be, do you build a big, an approach up front that you intend to be one size fits all, or do you sort of deal with it on one-off basis? You still have time to deal with it on a one-off basis. And frankly, there may be reasons to do it on a one-off basis, because if you get 10 or 15 or 20 of these, you can handle, you're not going to get 10,000 of them. I mean, it just doesn't happen that way. People built back in 2003 enormous systems to deal with this accounting rule, and then found that nobody asked for it. And so all of the money that went into those systems to build the accounting rule stuff was just a complete waste of everybody's money. We're having, again, people are going to work through it here on the access rights, but you absolutely don't have to convert your paper records.
Thank you.
Well, one thing that I think is interesting is about the counting of disclosures and the fact that few people will ask about them. I mean, one of the things that I've recognized over time in being a privacy professional, that I think sometimes that the biggest thing that we could do for people is to educate them about their rights, so that they knew what they were, they could exercise them as they wanted to, and they could scream if they didn't get them. And that might be, that might be the biggest service that we could do, as opposed to a lot of these other things. But I know from the experience in the federal government, there is a very similar kind of rule in the Privacy Act for an accounting of disclosures. And the same thing happened, is that lots of people are in government databases. Few people know about this, and what agencies do is they come up with basically, a manual process so that they know how to identify the disclosures if somebody asks them, and the courts have said that's fine to do it that way. You don't have to do it prospectively, and I guess we didn't learn from that though when we implemented this act. The other thing I was going to mention is that in terms of the patient access, is that it does seem unlikely that this is going to have any big effect, because it's about getting your electronic record if one exists. And I forgot what I was going to say. That's ridiculous. Well, the moment passed. Sorry. Oh, I know what I was, okay. Probably the bigger impact on organizations is maybe some of the things that are coming through on the meaningful use side, and that is this creation of patient portals, the blue button, that you've seen, the ability for patients to be able to look at a web-based system, see their information, they can download it, they can transfer it, they can control it to a larger extent. And I realize that doesn't impact everybody, but it certainly might have more of an impact here than some of these rules. So,
Let me use that to sort of move on maybe to the next point we want to try and cover, which is talk about some of the policy issues that are still out there. And I think there are two major issues that I've been giving a lot of thought to over the past couple of years that I think are really coming to the forefront with these high-tech changes. One of them is tied to the point Linda just mentioned about the meaningful use, which is we are seeing a big movement to getting patients more involved in their care, and everyone conceptually thinks that's a good idea. Wellness programs and awareness and transparency and all these other ideas. But we're in a situation right now where a lot of these privacy rules and security rules are actually creating impediments to making that work. Let me give you two quick examples. First one is totally simple, which is doctors don't want to communicate with patients by email largely because they think it violates the HIPAA security rule. They're probably right. But the whole point is, if patients want to communicate by email, it's easier to, that's become a real challenge, and we haven't figured out a good system to make that work yet. The other place where I'm seeing it is in the development of health information exchanges, and I've worked in this area for a lot. I was actually the co-chair of the group that Linda now works for before Linda got involved with it, sort of the first iteration at HHS, where the idea of health information exchanges is to make these records reliable, thorough, complete, available, so you don't have to repeat tests, you're going to avoid medical mistakes and things like that. And what we're doing is we're building a system around the country where every local and state health information exchanges is building in exceptions that give patients control over certain aspects of their records. And that means that those records, almost by definition from the start, are not going to be thorough, reliable, complete, and trustworthy. So it seems to me we've got a great idea. It's actually the one place I can think of in the healthcare system where we have the possibility of saving money and having better care. But right now we're moving towards a path that I think is destined to fail because we're basically building a network that's not going to do what we set out to do. So we've got to figure out how to get patients integrated in this, protect their rights, but still make these things work. The other development, which the high-tech rules are one step towards, is the scope of these rules. As I said earlier, the beginning, these rules apply to very specific entities, and that's there's a history to that that's tied to administrative simplification and the standardization of claims, but the logic it's crazy. No one would write privacy and security rules that way. I mean, for example, even today, if you happen to go to a doctor who doesn't do anything electronically, that doctor doesn't have to follow the privacy rules. I mean, it makes no sense that your rights as a patient, privacy rights as a patient, depend on how the doctor bills, but that's an accident of the history. The other example I like to use is if you're injured in a car accident, you turn in your medical records to your health insurer and your car insurer and let them figure it out. The health insurer has to follow HIPAA, the car insurer doesn't for the exact same medical records. Again, just a complete accident because car insurers weren't involved in portability of medical coverage. So we have these limited scopes. Now we've got things like personal health records vendors. Think of all the medical applications that are being built for websites. We've got all the websites. Basically, if people offer direct-to-consumer healthcare services, they're not covered by HIPAA. They're not anywhere. They're not even business associates in the scope of HIPAA. So we have all kinds of people across our healthcare system in growing volumes who have the exact same healthcare information, but just due to the accident of HIPAA, aren't covered by any of these HIPAA rules. So one of the questions is, are we going to move to a more broad-based system protecting healthcare privacy? I am always clear to people when I talk about this. HIPAA is not a healthcare privacy law. It's a law that protects the privacy of certain kinds of information when it's held by certain kinds of people in certain kinds of situations. It is absolutely not a general medical privacy law, and people don't understand that. Businesses often don't understand that. I don't think the regulators in Congress really even understand that yet. But right now we have this complete separation between what's in HIPAA and what's out of HIPAA. There are competitive issues, there's all kinds of challenges, but I do wonder whether we're going to get to a system where we're protecting the information rather than who's holding it for what purpose and in what situation, which is where we are right now.
So that would be the European model almost, right?
Well, it'd be something moving towards the European model. I mean, it could be the European model is all information in all contexts for all purposes. This is, one step would be to protect healthcare information. The second step would be to protect all information. We're never going to get there in this country, but I could easily see passing a healthcare privacy law. It's just as I said, and again, we're sort of backing into that. We're backing into a situation where we've got coverage of most of these things under different regulators, but that means completely different standards. And again, I don't think it's in patients' interest to have, for example, your rights, privacy rights in connection with a personal health record depend 100% on whether that personal health record is sponsored by your hospital or health insurer or sponsored by an independent company. Independent company, you have basically very few rights with that.
We have about 10 minutes left. I think there's just one more point maybe that we could speak briefly about. I'd like to talk a little bit about the notice of privacy practices that will need to be changed, I guess, under the rules. You want to?
Sure. HHS did no favors to anybody in these rules in two regards: business associate contracts and the notice of privacy practices. They basically required changes, which means all the business associate agreements need to be redone, and everybody's going to have to change their notice of privacy practices to make them longer. That's what we wanted, right? I don't know if anyone's ever read one of these at the doctor's office, but the notices are crazy. No one could possibly understand everything that's in there. You go into the doctor and you're supposed to sign something, but you're not signing you understand it, you're signing that they gave it to you. That's the only thing they have to ask you for. So what they've said is basically there's 3 or 4 or 5 things everybody needs to change in their privacy notices. And they're particularly odd because they're basically things that say, for example, you have to put in your privacy notice that we will tell you in the event we have a security breach that triggers the notification obligations. I don't personally understand what the point of putting that in the privacy notice is, because if you have to tell somebody, you're going to tell them then about it. Why tell everybody in advance that if something bad happens, we'll tell you about it? I don't get the point of that. Then they have to say things like, we are not allowed to sell your information unless we have your permission. Okay, great, but if you never ask them for it, that you can't sell it anyways, so what's that? So there's a variety of these things that have to be put in your privacy notices. Everybody's going to have to change their notices. Again, I don't really see that as a benefit to the patients, and I don't want to overplay the burden. I mean, you're going to have to change it. You're going to have to modify a document. HHS put into the rule that it actually will take you 1/3 of an hour and $28 in legal costs to change your privacy notice. Good luck with that. But so yeah, they've required these changes for sort of, they had a great opportunity. This is actually one of the funniest things in the privacy rule. There aren't actually a lot of funny things, but HHS said that they were going to make changes that went beyond the high-tech statute to basically respond to their last 10 years of implementing these rules, and they were going to make changes to just improve the rules. Then they didn't do anything on that. They could have dramatically changed the privacy notice. They didn't do that. The one new thing they put into this, and this is going to be monumentally important, so everyone listen very carefully to this. They said that if you have records about somebody who has been dead for more than 50 years, those records are no longer subject to HIPAA protections. You can all breathe a big sigh of relief now. I mean, that was their big change. And again, keep in mind, that means the person has been dead more than 50 years. The records could be 100 years old. And the reality of that means that that's a record that, say, was the latest that record could be created was 1963. That means from 1963 to 2003, those records had no HIPAA protections. Then they got HIPAA protections for 10 years between 2003 and 2013. Now they're lost. That was their big change from 10 years of implementing these regulations. So I was kind of disappointed that they didn't do anything with that.
Well, I love that. But I think one of the things that we see with some of what's been done with the notice of privacy practices is that we sort of failed to realize what the real limitations are of notice. We've had a tendency sort of overall to rely on it too heavily in terms of providing people with privacy rights by telling them everything what we're going to do. But frankly, I've been to the doctor's office too. They want me to sign that I've seen it, and then I always say, well, could I actually see it before, which leads me to believe probably nobody looks at it. It's not posted. I don't want to read it either. It's like, it's 6 or 7 pages. I mean, there's real limitations in the value that you can get from a notice of that type. And probably making it longer isn't, going to help either.
Well, and what HHS did is they basically said to people, you have to list in there every possible thing you could do with information. And if you don't list it, you can never do it. So you have to list in there things like, we may disclose your information in connection with a national security investigation. How often do you think that actually happens for most people? The first place you go is medical records, right, for national security investigations. So, but you have to put that in every single privacy notice because in 1 of a million times that might happen. So there's a list of about 15 things, for example, that are in there that you never do, but you have to write it in every privacy notice because then you couldn't the one time. So they've made that a disaster. And I think it really is, it's symptomatic of how they've looked at these issues with patients. They've been very heavy on imposing compliance obligations. there's an idea of getting patients involved and informing them, but they've done a bad job of making that actually work and actually helping the patients directly. I think it's clearly helped patients to have a security rule, for example, because security in the healthcare industry, it's not great, but it's clearly much better than it was. And that's absolutely of benefit to patients. And some of the other controls that have been put in because of the privacy rules, absolutely beneficial. But the sort of interaction part with patients, they've done a very bad job on.
Great. Well, thank
Question-
you. I think we have questions. We have time for a couple of questions if people have them.
I think one more.
Question?
Go ahead, you're close. We'll repeat. Yeah,
Is a privacy notice one time to the patient? Is a privacy notice one time to the patient, because some practices do it yearly? And can you send the privacy notice through a patient portal, and then you wouldn't have the signature, but you have sent it through the portal?
The patient notices are generally one time unless you change them in a material way. HHS is, the one thing they've done is they've tried to make it, they don't want to make it too burdensome to communicate this. So there are different rules for providers versus health insurers. Health insurers clearly are going to be able to use portals and things like that because for example, where I expect health insurers will be sending this out will be with annual enrollment in health plans going forward. Providers have there's some flexibility built in. You know, there are reasonable ways to get it distributed to people. You know, for example, for a lot of doctors, they gave it to a patient when they came 3 years ago, and you don't even know who your patient is. So I think what people are likely to do is they're likely to basically just put in, they're going to treat it like the beginning of the HIPAA era, and they're going to start just whatever the date is, they're going to just start giving it out to patients that come in on a going forward basis. And that should take care of it. The portal stuff is a little tricky because, again, you don't know whether patients are going. If you're using it in connection with patients clearly going there, that's probably going to be okay. But so I said, they didn't make writing the piece of paper any easier, and they didn't make it any easier for patients to understand it. They were a little understanding on. They didn't want to make people bear a big cost of distribution of those.
And for providers, it's for new patients, right? Isn't that the way it works?
No, because it's a material change. So it's for existing patients as long as they are in fact existing. I mean, the problem is how to figure out if someone's an existing patient if you haven't seen them in a couple years. But so it may. I think it's going to end up being not new patients. It will clearly need to be given to new patients. But I think for older patients, it will be the next time they come back after you've redone your notice, you're going to end up doing that. I mean, if you're a dialysis facility, you've got people that come in every week, you're going to have to figure out a way to get it to them. But for a hospital, when people come in once every other year, you're going to do it the next time they come in.
Right. So.
Great. Thank you very
all right.
much.
Thank you.
Thank you.
All right.
So the next session is in 15 minutes.